You were here with your attorney, Mr. Dufler, and the state's attorney. Here's this file. Thank you very much. In 25 CR 871, you were charged with the third-degree felony of assault on a security officer, it states, on or about May 29th of 2025.
Right out of the gate, a third-degree felony assault charge on a security officer. That's serious. And remember, in Texas, assaulting certain public servants like security officers bumps the stakes way higher than a regular assault. Would you be shocked to learn this could mean decades behind bars?
In Jefferson County, Texas, that it carries with it up to 10 years.
The plot thickens prior conviction for burglary. That's a legal landmine in Texas briars. Can enhance your current charge, turning a third-degree felony into a second-degree, doubling prison exposuriacus. That's the difference between maybe walking out in a few years or not walking out until your hair is gray.
Prison and a fine up to $10,000. Paragraph 2 of the indictment states that you were previously convicted of burglary of a habitation in the 252nd District Court next door on August 12th, 2020. If that is true, then if you're convicted of this third-degree felony of assault on a security officer, it then is enhanced to a second-degree felony punishment, which carries with it no less than 2 normal.
Whoa, did you catch that he just told the judge you are not my judge bowl move or reckless self-sabotage? What do you think? Standing up for himself or digging his own legal grave?
More than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand what you're facing with all of this, sir?
No, sir.
Okay. Okay. What do you have to say?
Judge, he has created a conflict of interest for me over the weekend. I received notice from the State Bar of Texas that he's filed a grievance against me.
Why?
Why?
Because he's not a sufficient counsel, and you are not my judge.
All right. What else? Anything else you want to say?
It just creates a conflict in our best.
Well, see, what the thing is, he could pull that for everybody.
Understand?
I mean, he could go on for 100 years like that's a master plan that doesn't work.
I don't know if that's his plan, but I know
Well, it doesn't
definitely I cannot represent him.
Well, what do we do if he pulls the stunt in every case?
I can't answer
Well,
that for it. But I know.
Well, I mean,
know
that's not the way it's meant to be. What's the good cause for this allegation?
because he's
How did he do that?
when he puts me on the defensive by filing a grievance against me.
I know, but
he's made me.
but if they're in bad faith, that doesn't matter. He said he hadn't figured out some master plan that works. That doesn't matter. It won't work. Is there any good reason that he would have had to have filed that?
No, sir.
Yes.
Then I'm talking to him, sir, Mr. Rude. No, if it's not, then it's in bad faith, so it doesn't cancel. Because it can be, we can do this all day long, and that's not the plan where you start.
And here it is, the classic courtroom twist. Self-representation, most judges will warn defendants hard against this. Why? Because representing yourself in a felony case is like showing up to a sword fight with butter knife. But hey, let's see how this plays out.
Who is it where would this end if they were able to do this? That's why it's not allowed. It's not allowed if it's in bad faith.
I don't know where he's going from here, but I do know that it creates a conflict for me. And
I know, but who would it not create a conflict to in the scheme of the whole universe if this was allowed to be filed in bad faith?
I don't know what he's going to get forth. He may never file a note. I don't
All
know.
right.
I don't know.
Well, maybe do you want to represent yourself though in this?
Yes, I can. Yes.
All right.
Represent myself.
All right.
I'll say
All right. Then you will represent
with my judge, Raquel West.
Yeah. That's not the case you're in, son. You're in this court. So you're going to deal with me on this.
How the judge just threw a pop quiz Texas Penal Code section 22 deals with assault of offenses translation. It's exactly the section tied to his case, and he waved it off like it's irrelevant, not a great start for Team Pro Se.
That's the way it works.
Okay. Set a trial date.
Yeah. Do you know one thing? We want to make sure that you understand this. Generally, people who represent themselves don't do a real good don't have a good success because generally the people who are the lawyers have gone to law school, have a law degree, have achieved a level of quality of education and pass the bar exam and have some experience to get in the felony court. All of those are important aspects in successfully handling a case. Do you understand that?
Yes, I've done all my research and I know
All right.
all the laws.
Yeah. What is section 22 of the Texas Penal Code, if you know all the laws?
Section 22 of the Texas Penal Code. That has nothing to do with my case.
I'm asking you, said you know all the
I
laws.
said
What
I
is
know
that?
all the law to my case.
Mhm.
To my case. Like there's no proof beyond any reasonable doubt that I committed these acts with any criminal intent.
So there is Lockton. He's officially going pro, so meaning he'll face a jury trial alone, no lawyer, no safety. Ned, do you think he's got a fighting chance, or is this a legal equivalent of jumping out of a plane without a parachute?
If I put in a motion to quash these indictments would automatically be quashed.
Well, we'll do whatever it is you need to do, but you're asking for a jury trial though, right?
Yeah, set a trial
Okay.
there.
Then we'll let a jury make the decision. That's the way it works. But do you understand there are pros and cons? This is really important that you have to tell me.
Yeah, I know a lot
You
of things,
thought-
Briggs.
Can I just finish my sentence?
No, you really can't because you're really disrespectful.
Oh, I'm the one that's interrupting you? Okay. Oh, well, nonetheless, the law says you have to understand that there are,
I don't understand this case because I didn't do it.
that doesn't matter. The grand jury indicted you and had
Yeah, the grand
evidence.
jury has evidence that are
Are
non-sufficient.
you going to just interrupt all the time?
Because you're not.
Can I just, would you be just so kind and respectful just to let somebody complete their
Dude,
sentence and then you have a fair
so I can
opportunity?
beat this case.
All right, all right. If that's, we can do this all day long. But your final answer is you want to represent yourself. You understand? their
Yes, sir.
concerns.
Yes, sir.
You're gonna be required to know the rules of evidence, the code of criminal procedure, the penal codes, be prepared for that. If you don't know that, then generally people are at a disadvantage. Do you understand? All right. If you decide at any time you want to get somebody to help you, let me know immediately and we'll get it done immediately, okay? All right. Anything else you want to add?
Nope.
All right, then we'll set it for trial. Thank you. All right, we had two cases, right? There were two cases on Ms. Brown, right? It's 871 and 872. And what we'll do is, I guess, which one does the DA's office want to go on that? Is it 872 hospital personnel? Is that the more, is that what y'all wanted? That looks like a third-degree felony. And he has a prior conviction alleged of a burglary. Okay. Next is Tondred County.